Before I begin, I would like to say that the Bronx are the best team in the state. That being said, we're just going to wait until the next slide is ready for us to go. Perfect. A little bit about myself. As I was introduced, my name is David Demic. I am originally from Frankfurt, Germany, still a German citizen. However, I've lived in Wyoming for the last 11 and a half years. I first came here in about 2005, where I was part of the Sheridan High School. Well, had the pleasure to go to the National History Day competition, so it was quite wonderful to meet with the We the People students as well as the Model United Nations students. And one little difference for me as compared to my colleagues is I didn't have a research question when I went to the International Criminal Court last summer. Rather, I started out with a personal question. What is international justice? How do we relate between countries, and how do we make peace when there's so much tendency towards war? So that's why the title officially is the balancing between the respect for sovereignty with the mandate against impunity. So a little bit about myself so you understand who you're dealing with. As I mentioned, I am originally from Germany. This is the German carnival, very, very cold during the February months. This is my mother on the left here with the wonderful 70s glasses. She emigrated from Yugoslavia, the former Yugoslavia, specifically Serbia, into Germany while it was still split in two. I was born in '88, so I was actually born in West Germany. Now, I was only a year old when the wall fell, but I do remember quite a few things happening during that time. The wall came down. For me, Germany was always unified. The reason that I'm showing you this slide, however, specifically is that my mother, being from Serbia originally, 1999 was glued to the German TV, watching German tornado bombers as well as American bombers hit infrastructure targets within Serbia. And being 11 years old, that was the first time that I really thought about why is one country that I call my home, Germany, bombing the other country that I also call my home, my cultural home? Much like many of you say, oh yeah, I'm 1/8 German. I've had that conversation many times as well. You know, and that was an interesting dynamic that my 11-year-old brain was not really able to work out. However, it led me down this path where I ended up in Sheridan, ultimately in Laramie. Then Dr. Garrison and I actually also went to the Model United Nations in New York. So this was actually in the United Nations building in New York itself. And that was an amazing opportunity. And ultimately, it led me last summer to the International Criminal Court in The Hague, where I not only had the pleasure to work with a former alumna from the University College of Law, where I'm completing my degree now, my JD degree. For those of you that know her, Ida Dijkstal. But I also had the pleasure to work with what is called a mock trial, and this is actually within the chambers of the International Criminal Tribunal for the former Yugoslavia, or short ICTY. We'll just call it the Yugoslavia Court. That being said, I want to give you all a little bit of a background. So that was my personal question. How do we make peace in the world? And ultimately, you will see that it comes down to sovereignty, respecting sovereignty versus bringing impunity, bringing someone to justice, war criminal specifically. So without really making this into how to make a war criminal, right? How to make a murder, little allegory there for those of you that watch Netflix. A little bit about the International Criminal Court. This is a picture of the criminal court. Thanks to the Malcolm Wallop Fund as well as a few other sources of funding, I was able to live about 45 seconds from the court, which was amazing. This is the view as you walk toward it. A little bit on the history of the court. After World War II, we had two major international criminal tribunals, specifically the military tribunals for the Tokyo trials as well as the Nuremberg trials. For those of you that are familiar with this, you might already know this, but there was no international criminal law at the time. So the perpetrators of some of the worst crimes against humanity ever committed had no law under which they could be prosecuted. So especially American litigators did a phenomenal job laying a foundation and a legacy for prosecuting future war criminals, ultimately leading to the ICTY, the Yugoslav courts, as well as the ICTR, the International Criminal Tribunal for Rwanda. After that, and toward the end of the 90s, countries had been considering the idea, instead of having very limited courts for a specific incidents, which can cost a lot of money to run, but is very limited, let's make a permanent court. Let's make a court that can hear those cases on a rolling basis, if you want to call it that. And that brought about the Rome Statute. The Rome Statute specifically gives the International Criminal Court three purposes. And think of the Rome Statute as the constitution of the ICC. It is supposed to build a permanent institution that can handle the most serious crimes of international law and be complementary to domestic law. Now, complementarity is really what I would like to focus on here today, because that is that balancing act between having respect for the sovereignty of a state to prosecute the criminals of its own versus the international court coming in and making sure that those criminals are not being allowed to exist in impunity. Right. So the official definition up there is the domestic jurisdictions enjoy primacy. Primacy, again, meaning that domestic jurisdictions, if they're capable to hear a case, should hear the case first before the ICC can step in. Now, again, as with many things, and for those of you that had to suffer through a legal education, there are many caveats and exceptions to all the rules. You know that if there's inadequate or ineffective prosecution, trials, the ICC can step in, and this is found in the Article 17 of the ICC statute, which really brings me to why we're here today. So we have this tension. We want to respect the state's sovereignty because we don't want to undermine their judiciary. We don't want to undermine their view in the world, and especially for the people that live within the country, that they are not capable of prosecuting the crimes in their country. However, oftentimes in a war-torn country like Iraq, the judicial infrastructure simply doesn't exist to be able to do that, or at least that's our perception. So we have to balance that. To explain a little bit of the comics that are up there, one of the main criticism against the ICC is that it has only really prosecuted members of the African countries. Furthermore, this has often been seen as an undermining factors for those African countries, that they cannot properly run their own governments without the ICC, and specifically us, the West, the northern countries, as they're most often in the international community referred to, are kind of dominating in their judicial respect. So what did I do? I worked on two major cases before the ICC. One of those cases, I actually worked on a defense team. And you see here Abdullah al-Sanusi. I will speak about Mr. Sanusi a little bit more in a second, but for those of you that know him, know that he has been alleged of being a war criminal. And the first thought that would go through my head if I were you is, why would this nice little German boy try to represent this war criminal before the court, correct? And I would like to bring up a conversation that I had with a Pakistani international student while I was weed whacking up at Sheridan College many years ago. He asked me why I wanted to go to law school, and I explained to him, because it's justice and balance and having a prosecutor and defendant. And he asked me, if you have someone that you know is a rapist, why would you defend him? You know it. You can just find him guilty. You put him in jail or do whatever. And that was a question that always stuck with me. And my answer that I found working at the International Criminal Court, defending someone like Mr. al-Sanusi, is that we need to make sure that the justice process is defensible, because that ultimately is what builds democracy. Without a proper justice process, we have what is called a kangaroo court, where the powerful, like the Star Chambers in the UK, were able to simply prosecute anyone that they want to with impunity themselves. We have to ensure, as the populace, as the citizenship, as the attorneys, that the justice system can function properly. So, going back to Mr. al-Sanusi, you will see in this picture Mr. Muammar Gaddafi on your perspective to the right, and Mr. al-Sanusi on the left. Muammar Gaddafi was the controlling authoritarian, let's call him dictator, of Libya for 40-some years after a military putsch. Mr. al-Sanusi was the head of intelligence, of military intelligence for Libya, or more commonly referred to, spy chief. Now, Mr. Muammar Gaddafi was becoming increasingly concerned, as the ambassador has referred to, the Arab Spring spreading over from Tunisia into Egypt. So he ordered Mr. al-Sanusi to do whatever was necessary in order to suppress this movement. This brings us to the reason why this ended up being before the International Criminal Court. You see here a picture of Fatih Terbil. Mr. Terbil was or continues to be the civil rights lawyer for the victims of those murdered or allegedly murdered at the Abu Salim prison massacre of 1996. A little bit of more background. Mr. al-Sanusi is alleged to have ordered the killing of roughly 2,000 prison inmates who were rebelling against the conditions within a prison in Libya. He was representing the victims. He brought the case. He was trying to bring the case to Libyan courts, was arrested, was put into a prison for that, and roughly 500 individuals were protesting against his imprisonment. That protest was violently put down. Hundreds died. even more were injured. This brought the International Criminal Court to bring 3 warrants against Muammar Gaddafi, his son al-Islam Gaddafi, as well as my client ultimately, Mr. al-Sanusi. Now, after the warrant was issued, Mr. al-Sanusi as well as Mr. Gaddafi were able to circumvent being caught by Libyan officials as well as other officials in the northern African continent. However, ultimately, about a year later, Mr. al-Sanusi was caught in Mauritania. He was trying to leave Nouakchott airport. Now, Mauritania, also a Muslim country, was unwilling to extradite Mr. al-Sanusi to any country that was not Muslim. There were requests by France to have him extradited there because Mr. al-Sanusi has also been alleged to have ordered terror bombings against flights. He was requested, of course, by the ICC to be extradited there, extradition meaning sent to that country. And then ultimately Libya also sent a request for extradition because it wanted to try Mr. al-Sanusi under its domestic laws. Mauritania complied with the request by Libya because it is also a Muslim country. So it trusted that its justice process would be served and not a northern, or from our perspective, Western country perspective. Which brings us to the actual detention and some of the issues that arose. And that's why I mentioned this story of me representing Mr. al-Sanusi. If we want to ensure that the judgment that we bring against someone is just and defendable, we have to ensure that the process to get to that judgment has to be proper. Here we see a picture of Mr. Gaddafi's son, al-Islam Gaddafi, being beat and essentially prodded into giving a confession. There were multiple such issues as the council that I worked for, myself, anybody else, was never allowed to actually speak with Mr. al-Sanusi. The same was true for al-Islam Gaddafi as well. They were not given any opportunity to bring counter evidence against their claims. They never saw a local attorney for their representation. And there's also evidence of coerced confessions on their part. Ultimately, there was a trial held against all of them, and all of them were sentenced to death. This is what we call in the legal community a kangaroo court. Now, it has nothing to do with Australia, and I know Australia has been kind of on the news here lately for the last couple days. But the point of a kangaroo court, as I said before, is that it holds whoever it wants responsible for whatever it thinks is the just cause. And it will do so without giving that other side an opportunity to fight against that claim. Now, I would like to also point out the International Criminal Court follows the continental system. So where I'm from, Europe, it's much more, there's one judge, and that judge has quite a bit of leeway. Doesn't really have to follow precedent, just has to follow statutory law. In America, we believe, and yes, I include myself in that, not being an American citizen, but having very much learned the American system, we believe in an adversarial system, where the truth is determined by having one side present its version of the truth, the other side presenting that version of the truth, and then having the fact finder, in this case a jury, for example, determine what the actual truth is. Now we have a case where only the prosecution was able to bring evidence. Mr. al-Sanusi was just sitting behind, essentially in a cage with the other dozen or so accused and was sentenced to death. That brings me to that ultimate question. Libya is a country that is trying to recover from the aftershocks of the Arab Spring, something that, as the ambassador has pointed out, we hope was going to make Libya a stronger democracy. And yet it's sectarianism that is tearing Libya still apart on a low-key way, if you want to think about it that way. But ultimately, it is still not necessarily a government that can hold these kind of hearings without having some kind of interest slip into the judicial process. Therefore, while the ICC ultimately stepped down and recognized the domestic decision, it is, again, the council that I work for, in my opinion, that it was not the right decision to do so, because ultimately, Mr. al-Islam Gaddafi was let off the hook. He has been granted amnesty, the death sentence has obviously been commuted, and he can now travel freely within the country. That means that Mr. al-Islam Gaddafi had some kind of information or some kind of key players in the background that were able to excommunicate his sentence, where Mr. al-Gaddafi or Mr. al-Sanusi did not. So that is another example of why this was ultimately a kangaroo court. The biggest concern from from my international law perspective, the law that I hope to practice one day is that not only does it undermine the Libyan government, but it also undermines our mission to bring justice to those perpetrators of war crimes, that it brings impunity to the world, that a court simply has to claim complementarity, as I pointed out, the third prong, and undermine the justice process internationally. With that, there's not much more to say. The problem is Libya has control over that. Libya had control over that, and the ICC does not necessarily have the power relations to enforce its judgment or enforce the warrant being brought. It relies on the sovereignty of nations to cooperate with it. And ultimately, what we have to look to is soft power mechanisms, trying to work with the individuals within the country, as Eric has pointed out, trying to build those kind of relations, as the ambassador has talked about, in order to effect justice in the world. And of course, I would have not been able to say any of this today to you or try to make any kind of jokes about the Bronx being better than whatever is in Cheyenne. You know, I obviously don't know what they are. Without the Malcolm Wallop Fund, as well as the Dick and Lynn Cheney Fund, and also the UW Center for International Human Rights. Thank you very much.